Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where the heck am I today? Well, I'm outside a security club, and you're asking yourself, Bill, what the hell are you doing outside a security gun club? Well, they don't have any power. Why am I not in my studio? Well, we don't have any power. In fact, most of the Puget Sound region right here is still without power. But hey, to show how dedicated I am to the cause, I came out here before the rain and wind started up again, got outside the gun club, and we're going to talk about a really, really important case just filed by our good friends with the Firearms Policy Coalition. It has to do with New York's law, which basically says that the only way you're ever going to get a permission slip to be able to carry a firearm inside that state and thus be able to preserve your own life is you have to be a resident of that state or you have to predominantly do business inside of that state. I think it's time for that law to die the miserable death that it deserves. And so today, let's introduce you to a lawsuit that intends to do just that. Let's spend a few minutes and let's talk about how to stop one of New York's most restrictive gun laws. Okay, so who is today's video sponsor?
Taylor Freelance.
No, seriously, who's today's video sponsor?
Taylor Freelance.
Taylor Freelance. Okay, you realize what Google is going to do to this video if we have Taylor Freelance advertised on this channel. Okay, well, here goes nothing. All right, hey, listen, before we get going too far down the road we're going down, proud to announce that this video is brought to you by Taylor Freelance. That's right, American-owned, American-made, right there in Bellingham, Washington. They are making some of the best components for your you-know-what out there. Now, listen, this is normally where I'd put all the cool B-roll up and show you all the cool things that they're making up there at Taylor Freelance. But if I do that, well, YouTube and Google is going to get a little ticked off at us. But listen, if you just want to know what Taylor Freelance is in a nutshell, it's really this simple. They do not make your firearm, got that, Google? They do not make firearms, but they will make your firearm a lot better. If you're ready to take your firearm to the next level, if you're ready to customize your firearm so that you are more proficient in it, visit all of our good friends at Taylor Freelance. What?
Don't mention their website.
Oh, yeah, that's right. Thank you. Yeah, hey, listen, for more information, go ahead and click on my partner page right there. And there you'll find the link to Taylor Freelance so you can check out all the cool things that they're doing. For more information, visit my partner page. Okay, America, again, I apologize for the noise. I got freeways all around me. The case we're talking about today is the case of Shaffer v. Quattrone. It is a case that was just filed in the United States District Court for the Western District of New York. It is brought to us by our good friends at the Firearms Policy Coalition. Let me set up the case for you in a nutshell. The named plaintiffs are not only members of the Firearms Policy Coalition, but are all licensed concealed carriers in other states who do spend quite a bit of time in the state of New York. Unfortunately, because they are not residents in New York and they don't predominantly conduct business inside the state of New York, not a single one of them will ever be allowed to lawfully carry a firearm inside of the state of New York. They, along with the Firearms Policy Coalition, is bringing suit saying, hey, wait a second, I did not realize that my constitutional rights end at a state line, which theoretically they don't, unless, of course, we're talking about Second Amendment rights. How does FPC set it up? The Second Amendment to the United States Constitution guarantees the right of the people to keep and bear arms. Being part of the people, plaintiffs and other law-abiding U.S. citizens have a fundamental, constitutionally guaranteed right to keep and bear arms for self-defense and other lawful purposes. Now, you may sit there and go, whoa, wait a second. I thought that Bruin kind of struck down New York's concealed carry law, and didn't they completely revamp it? Well, they did completely revamp parts of it. But what they did not revamp was the requirement. And it's always been there, and it's still there, that you are either a citizen of New York or your primary place of business is inside the state of New York. Beyond that, you don't qualify for a license, period. So as FPC points out, despite the U.S. Constitution's command that citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states, New York did not amend its prohibition on non-resident applications for firearm licenses. The statute reads, applications shall be made and renewed in the case of a license to carry or possess a pistol or revolver or to purchase or take possession of a semi-automatic rifle to the licensing officer in the city or county as the case may be where the applicant resides, is principally employed, or has his or her principal place of business as merchant or storekeeper. So think about it. The only individuals that the state of New York believes have lives that are worth defending and saving are those citizens of the state or those who are principally doing business inside the state. You may be a person that lives very close to the New York state line. You may be a person who is frequently inside the state of New York, but in the eyes of the state of New York, your life is not worth preserving. As a result of the ban, most non-residents who visit New York, whether occasionally or regularly, are ineligible to apply for any New York State firearms license, and so are prohibited from carrying or possessing loaded, operable firearms and semi-automatic rifles in New York. Thus, the individual plaintiffs, other similarly situated FPC members, and many other non-residents are barred from lawfully possessing or carrying a firearm in public for self-defense when they visit New York. That is exactly what the problem is, and therefore FPC wisely points out the ban is unconstitutional. Citizens do not lose protection of their rights under the First Amendment speech or religion clause when they cross state lines, nor do they lose their protections under the Fourth Amendment's prohibition on unreasonable searches and seizures. Likewise, they do not surrender their Second Amendment protected rights when they travel outside of their home states. And for that reason, FPC correctly pleads to the court. In sum, New York's non-resident ban violates the Second and 14th Amendments to the United States Constitution, as well as Article 4 of the same, the Privileges and Immunities Clause. This court should enter a judgment that declares the ban unconstitutional and enjoins defendants from rejecting firearms license applications from non-residents whose applications are otherwise proper. Okay, so they are declaring that the laws themselves are unconstitutional, that they are depriving the individually named plaintiffs of their constitutional rights under the color state title, which means that that now is in violation of 42 United States Code Section 1983. But hey, what do we say here at Washington Gun Law all the time? You can have all the lawsuits you want. You gotta have a remedy. What's the remedies that the plaintiffs are asking for here? One, that this court issue a declaratory judgment that New York's laws barring non-residents from possessing or carrying firearms in public are unconstitutional under the Second and 14th Amendments to the U.S. Constitution. Two, that this court issue a declaratory judgment that New York laws barring non-residents from possessing or carrying firearms in public are unconstitutional under the Privileges and Immunities Clause of Article 4, Section 2 of the U.S. Constitution. Three, that this court permanently enjoin defendants, officers, agents, servants, employees, and attorneys, and other persons who are in active concert or participation with defendants from enforcing the residency requirement for applicants with respect to citizens of the United States who are not residents of New York, or in the alternative, from enforcing New York's ban on possession and carry against plaintiffs and plaintiff firearms policy coalitions, similarly situated members. And then, of course, they want some additional items, typically attorney's fees and things like that, to be awarded to them. But the bottom line is, what are they asking for? Yeah, they're asking for this residency requirement to be absolutely stricken from the law, as it should. They're dead right. You do not lose any other constitutional right when you cross the state line. Why is it that the Second Amendment right is the most disfavored right? Okay, the case once again is Shaffer v. Quattrone. We're going to link up the complaint down below so you can geek out on it for yourself. We're going to put a link down there for the Firearms Policy Coalition, so if you want to show them some love, you can do that as well. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there. You let us know. If you want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From outside here, freezing my shtukas off of Security Gun Club in Woodinville, Washington, thanks for watching. Stay safe.